furthermore, and in keeping with previous of the seminars, that there will be a digest that we've put together, and that will come out to you tomorrow. That will contain salient links and things of that nature, which means that you don't have to scribble if you don't wish to during the course of the time that we are speaking. Obviously, you're very welcome to do so, but it's not vital, because the references that we make and the pointers that we make will be in a digest, and you'll be sent those. The third thing to mention, is by way of housekeeping, is that there is a Q&A button which will be reserved for questions. We propose to take about 40 minutes thereabout to discuss and consider the matters that we wish to discuss with you, and then leave open around 20 minutes or so for questions. If we go over our time slot, I'm sure you'll forgive us, but we're happy to carry on a little bit past 5 if that means we can accommodate some more questions, and that's what we would like to do. So, as I say, very warm welcome to you all to the third in this series. This is on cryptocurrency regulation, regulation, and regulation. It's actually part one of 2 parts of this webinar, because what we're going to do today is talk in general terms about the regulatory landscape, and it's a regulatory landscape across the world. We're going to visit the US today, we're going to visit Switzerland, we're going to visit Singapore, and possibly even Hong Kong. So we're going to be all over the world, from the luxury of where we're all sitting on this Zoom. And then the second one of these, and I'll give these dates at the end of the webinar, will deal with practical considerations, and so things that we as practitioners have come across. So we hope that you'll see it in a form of a 2-parter, this being the first part, and then a second one, and I'll give you the date for that at the end. There is a real drive for regulation of cryptocurrency, and that principally is based upon 4 key characteristics. There's the suggestion, and I'll come on to discuss these matters, and so will the other panelists, of the fact of theft and fraud related to crypto. There's the ransomware demands, which are becoming prevalent, as we all know. There is the effect of initial coin offerings, or ICOs. You may have heard those methods of fundraising. And there's obviously the important factors of consumer protection. What we say as part of the 36 commercial team dealing in this field, as we do on a daily basis, is that we are very positive about cryptocurrency. We understand that it has to be regulated, but we do believe that there is a very strong and central place for cryptocurrency as we develop and the UK develops in the world. And we also believe that the world is ripe for this form of technological innovation. So I'm going to introduce myself very briefly, and then my co-panelists. Dean Armstrong QC, very good afternoon, as I say, to you all. Author of 3 current textbooks: Cybersecurity Law and Practice, Principles of Cyber Litigation, and Blockchain and Cryptocurrency. There's a cyber risk and insurance book, which is about to come out any minute now, I think probably now next month. And as I'll mention in a moment, one to come with one of my co-panelists, Marc Samuels, when I introduce him. There's also Celso Azevedo, who is a member of our 36 commercial team. He is, as well as being a barrister with us, he is an attorney in New York. He is a fellow of the Chartered Institute of Arbitrators. He has over 20 years in insurance, cybersecurity, data breach, cryptocurrency, fraud, asset trading, tracing, and regulation investigations, both advisory and contentious. He also is a published author. He's the author of a Sweet and Maxwell publication, Cyber Risks, Insurance, Law and Practice. And you'll be hearing from Celso about the US angle shortly. We're also delighted to be joined by Ceri Davis, also a barrister with us at 36 Commercial, an attorney and also a counsellor of law in New York, USA. She specialises in cyber, data and technology matters, and commercial crime and regulation. And I had the absolute pleasure of her being a co-author of mine on our book, Cyber Litigation, the Legal Principles, which were published last year by Bloomsbury. And Marc Samuels, barrister at 36 Commercial. Marc practices on cyber and commercial law and matrimonial finance. He's the author of Commercial Contracts for UK Companies, Formation to Exit. That was published this year by Bloomsbury. And as I say, it's my pleasure as well that Marc and I are also authoring a book on crypto assets, and that will be forthcoming probably at the beginning of next year. So we're going to take you through the cryptocurrency regulatory aspects of the US, the UK, Switzerland, Singapore, and Hong Kong. Now, I'm just going to give you a little health warning. I'm sure it wouldn't be a lawyer's meeting without a health warning. But my colleagues who are discussing the Switzerland, Singapore, and Hong Kong matters aren't qualified as lawyers in those jurisdictions, but what they are able to do is to give you an overview of the regulatory regime, and so that you can see cryptocurrency in the proper context. Because as one who specializes in practicing this form of law, the one thing is absolutely clear, is it is a world situation. There's a global scale and global context for this. So with that, I shall end the introduction and just give you a very short overview on cryptocurrency. Those of you who have read a newspaper or looked on the internet, I suspect most of you, will have seen that Bitcoin is in the midst of a bull run. There's been a slight correction recently, but it reached a new peak of $60,000 per Bitcoin in March of 2020. An important statistic, in February 2021, the aggregate value of the 18.6 million Bitcoins tokens currently in circulation surpassed $1 trillion, which was half of the entire US cryptocurrency market. At the same time, other cryptocurrencies have risen alongside the prices of many, the share prices of many crypto-related businesses. It's very much a boom time in the crypto world. And the tech giants, as well as other giants, have been active in their involvement and their adoption of cryptocurrency. MasterCard is integrating Bitcoin into its financial payment system. BNY Mellon has announced plans to hold Bitcoin and other cryptocurrencies on behalf of its clients. You may have read that Tesla recently purchased $1.5 billion for its corporate treasury. And this reflects a surge of institutional interest in the emerging Bitcoin and crypto asset class. One thing that we are absolutely sure about is that Bitcoin is here to stay, and it's firmly rooted in the financial landscape as we move forward. Indeed, we had the UK Chancellor, Rishi Sunak, discussing Britcoin recently about developments in crypto in the UK. Our view, as we say, is that we welcome these initiatives. We are very excited about the possibilities. We also understand and believe that there is a need for regulation, as there is the need for regulation in other financial markets. The regulatory aspect is bound to grow. There are some, and those who know me will know that I'm not backward in giving my views about various aspects of regulators as well as public figures. There are some who have cast doubt upon Bitcoin in particular, cryptocurrency in general, and its utility and its usefulness. We had on the 13th of January, Christine Lagarde, the president of the European Central Bank, calling for global regulation of Bitcoin. That is completely, if I may say so, understandable, but I think it's right to say, certainly it's my opinion, it's right to say that the words she chose to describe that initiative were most unfortunate. She called it a highly speculative asset, which has conducted some funny business and some interesting and totally reprehensible money laundering activity. Can I say it's impossible to disagree with her more in terms of her putting Bitcoin in this particular box on its own. There has been money laundering activity with fiat currencies for years and years and years. So what is required, as far as I am concerned, is an education piece, which we hope we can at least assist in bringing those of you who've taken the trouble to listen to us today, to candidly to suggest that Bitcoin is going to go away is similar to a King Canute type approach. It's never going to happen. It is here to stay for us. So with those introductory remarks, what I'm going to do now, and you'll hear, to give you, those of you an opportunity to leave if you'd like to, not at the moment, I'll be coming back later. Happily don't leave for the minute, because you've got a very interesting speaker in Celso who's going to talk to you about the developments in the USA.
Thank you, Dean. In the United States, the regulatory initiatives dealing with cryptocurrencies in 2020 and 2021 have been the continuation of a balancing act between, on the one hand, the need to protect the financial system and customers' interests against a disruptive technology, and on the other hand, trying to avoid stifling technological innovations in this industry, which is crucial for future economic development. But the initial question which we must ask must be why so many regulatory initiatives have occurred in 2020 and 2021. To answer this question, I will only focus, as Dean mentioned, on 4 main areas of regulatory concern. And they are, first, the steep increase in ransomware demands for payments in cryptocurrencies. Second, the use of anonymizing decentralized exchanges in suspected anti-money laundering activities. Third, the use of initial coin offerings as scams. And fourth, the general lack of national consumer protection regulations in what is a multi-jurisdictional industry. So turning to the first area of concern, by some accounts, ransomware payment demands in cryptocurrency has increased by between 300 and 700% in 2020. As a result, in this area, there were 2 regulatory developments that occurred in the US in 2020. First, as part of the US anti-terrorism financing sanctions regime, in October 2020, the US Treasury Department's Office of Foreign Assets Control, OFAC, issued an advisory or a regulatory guidance to emphasize that OFAC's sanctions enforcement guidelines will not only apply to banks and regulated entities, but also apply to insurers, forensic experts, and incident response service providers who may be involved in assisting with the ransom payment in cryptocurrency to a sanctioned entity or individual. And as a result, these service providers may also be penalized jointly with the ransomware victim under the OFAC regulations. The second advisory relating to ransomware payments was issued on the same day, in October, by the Treasury Department's Financial Crimes Enforcement Network, FinCEN. And in summary, it reiterates that financial institutions must file a SAR, a Suspicious Activity Report, in relation to any ransom payments made through them. It will be interesting to see whether these new guidelines have any effect at all in the reduction of ransomware payments in cryptocurrencies in 2021 and 2022. So that was the first area of concern. Now, if I can turn as a group to the other 3 areas of regulatory concern, which relates to number 1, decentralized exchanges, number 2, initial coin offerings, and number 3, lack of consumer protection. Basically, giving some background, in 2011 and 2013, in the US, FinCEN already released a paper stating that US registered businesses, and that's the important part, they must be US registered businesses, which were exchanges, crypto exchanges, and administrators of virtual currencies, were subject to the Bank Secrecy Act, the BSA, and as a result, they must register as money services businesses, MSBs, and comply with anti-money laundering rules. But turning to more recent developments in 2020 and 2021, it all started in October 2020 when the US's DOJ issued a document entitled Cryptocurrency Enforcement Framework, which highlighted that peer-to-peer decentralized exchange. So this is the concern with decentralized exchanges that I was raising earlier. So any peer-to-peer decentralized exchange is a money services business, which means it is required to abide by anti-money laundering rules under the BSA. Now, following on after this October document, in December 2020, FinCEN issued a notice of proposed rulemaking expanding the anti-money laundering know your client requirements so that banks and money laundering businesses, so centralized custodial crypto exchanges, would now be required to comply with know your client identification requirements in relation to transactions above certain thresholds. And this is the important part, involving, number one, unhosted or self-hosted crypto wallets, which are not hosted by a custodial crypto exchange. So the custodial crypto exchange, they have been subject to these rules since 2013. Now, the proposal is to expand them to unhosted or self-hosted crypto wallets and foreign-based custodial cryptocurrency exchanges located in certain jurisdictions identified by FinCEN. But the question here is whether this is a good or a bad regulation. And industry observers have noted that there are many ways to bypass these rules, which will benefit foreign-based crypto exchanges, which are outside the jurisdictional remit of the United States regulators, to the detriment of the US exchanges. So that is a problem. However, despite these concerns, FinCEN issued notices reopening the consultation period on the proposed legislation in January and February 2020, and extended the consultation period, which has now expired on the 29th of March 2021, so just last month, at the end of last month. So this is what happened in the US. But internationally, on the 23rd of March 2021, so end of last month as well, last week of last month, the Financial Action Task Force, the FATF, which has 39 member countries and is an intergovernmental organization that was set up to develop policies to combat anti-money laundering and terrorism financing worldwide, has now launched a new public consultation on virtual assets to update their guidance of 2019, and which applies that now. It is proposed to apply the travel rule, it's called the travel rule, to virtual asset service providers, we call them VASPs, by expanding the definition of VASPs so that it will apply not just to spot exchange and custodial centralized exchanges, but also to decentralized finance. And by decentralized finance, they mean peer-to-peer transactions, stable coins, and decentralized exchanges. So similar to what it is being suggested in the US, but to broaden it via what is called the travel rule. And the problem here is that the travel rule compliance requirements for exchanges, they will require that these exchanges, if this is enforced in the US, they will have to demand the transmission, the travel from any counterparty foreign exchange of their senders, proof of physical address, national ID or passport number, custodial identification number, date and place of birth information, etc., of the senders of the crypto assets. And now, on the 20th of April 2021, this public consultation period has expired, and the review of this guidance of 2019 is expected to be issued by FATF around June 2021, around June this year. So that's what's happening internationally. So, and I will just make two final points. First, in relation to the travel rule, we must remember that already in March 2020, March not last year, the joint working group issued the Inter-VASP messaging standard, the IVMS 101, which provides a common system for communication of required originator and beneficiary information between crypto exchanges, or at least custodial crypto exchanges. And finally, on 20 April 2021, so April this year, just 9 days ago, the US's House of Representatives passed a bipartisan bill called the Eliminate Barriers to Innovation Act of 2021. And if it is enacted into law, it will create a digital assets working group, the DAWG, between the Securities and Exchange Commission, the SEC, and the Commodity Futures Trading Commission, the CFTC, in order to clarify when the SEC has jurisdiction over digital assets, if they are considered to be securities. So it is opening the door here for clear regulation to state that cryptocurrencies are securities, crypto assets are securities. And when the CFTC has enforcement jurisdiction in case of when digital assets are classified as commodities. So these are the main developments that have been happening in the US at the moment. And we're going to have to wait to see what happens for the rest of 2021. There will be opportunities for questions at the end, but now I will pass it to Marc, who will discuss the regulatory developments in Switzerland.
I think now, Celso, it's to me.
Oh, so back to you. Is this true, Dean? So
yeah,
apologies.
Don't worry. Often it's the case that the head of chambers is often ignored. Don't worry about that. That happens sometimes. And I'm pleased, actually, that when Celso was dealing with the FATF draft rules on VASPs, that he was kind about them, since I was one of the parties that drafted them. So it was nice, at least I didn't get too much stick or abuse on that. So let me now dive into the UK regulatory aspects. The FCA position on crypto assets, cryptocurrency, recently has been as stark as the following warning that was issued on the 11th of January 2021. It issued a notice warning customers of the risk of investments advertising high returns based on crypto assets. And it said, rather starkly, investing in crypto assets or investments and lending linked to them generally involves taking very high risks with investors' money. If consumers invest in these types of product, they should be prepared to lose all of their money. A very bold message from the FCA. I understand entirely what it's aimed at. It's certainly seeking to remind consumers that crypto asset related investments are something which is new. And I think candidly, really, that the real issue that they're getting to there is that there is no access to the financial ombudsman service, or there's no access to the financial services compensation scheme in respect to crypto assets currently. So understandable concern from the FCA. Here is my health warning about the FCA. The FCA are playing catch up, I would candidly say, in terms of this new area. Some of their guidance is less than helpful. They do their very best to be helpful. I'm not suggesting that they're not, but to be absolutely honest, the only way that, and these days regulatory bodies will never give you a steer as a client or a customer or as on behalf of somebody else. The only real way to do this is to take proper professional advice in respect of these matters. There are ways through each of these. There clearly has to be an element of circumspection. But don't be put off this market, because it's a market that actually is of huge value, provided you get the proper advice. So what's the current UK policy on crypto assets? Well, it's rooted in a report of October 2018, a task force final report, the task force report, in fact, as it was called. It identified cryptocurrencies as a subset of crypto assets, and it provided definitions, non-legislative definitions, to 3 subcategories of asset. And it's really important for those of you who are advising or talking to prospective clients about this area to know the distinction between these 3, because it has hugely different effects upon the regulatory treatment or otherwise. There are exchange tokens, and those are cryptocurrencies such as Bitcoin and Litecoin. They use distributed ledger technology. The most best known is the blockchain, and they're not issued or backed by a central bank or other body. They are a means of exchange or investment. The second general category, security tokens, they constitute what's known as a specified investment, and they are pursuant and regulated by the Financial Services and Markets Act of 2000, the Regulated Activities Order, in fact, of that act. And they also may constitute transferable securities or instruments under MiFID II. And then third, there's utility tokens. They can be redeemed. Generally, they are simply ways of assisting with the general product. They are not in and of themselves a financial instrument, and therefore they are not regulated and subject to the scrutiny of the Financial Services Association, Financial Conduct Authority. So the position in the UK is that there is no blanket prohibition on cryptocurrency, but there's no regulatory regime which is specific either. So there's a bit of a patchwork. Often it's the case, as you will know, in UK regulation and legislation, that it's a patchwork. Cryptocurrency, crypto assets are no exception to this. So it really depends on whether they fall for regulation between 3 areas, either within the scope of the Financial Services and Markets Act or the AML regime, or whether they are payment services, electronic money regime under the Payment Services Regulations, Electronic Money Regulations 2011. And so, and what generally, and this is actually, this plurality of regimes is reflected in what's described as the taxonomy, which is contained in the FCA guidance on crypto assets, published in July 2019. And that's the latest guidance, which refines the definitions contained in the task force. And candidly, as I do pretty much on a day-to-day basis, the only way really to look at this is to decide on a case-by-case basis, is it regulated? Is it regulated activity or is it not? There are useful indicators as to whether something is a regulated or unregulated token. Do they give rights and entitlement? That tends to make it more likely to be regulated. But it is very, very difficult to make it a blanket view about this. But bear in mind, it's a criminal offence to conduct investment business without proper authorisation. So what happens is that the UK really, the UK approach is that one has to say to look on a case-by-case basis. Generally, it's right to say that if something, if a coin or a token gives rights into a financial instrument, then it's likely to be regulated. I had a case recently where the token dressed up as it was as a utility token and therefore not requiring regulation. In fact, when one looked at it, gave a right to a debenture in the company's assets or liabilities. That would have been, and certainly it was my view, that should be regulated. But thereby hangs the problem that it's not as straightforward. And also, candidly, some people do dress utility tokens, they dress regulated tokens up as utility tokens. And that's also going to fall foul on a risk-based approach by the FCA. So beware, it's not just because it says it's a utility token doesn't mean to say that it is, and doesn't mean to say that the FCA would take that view. Look underneath at whether it actually establishes a right in a particular investment. So in January 2020, the UK money laundering and terrorist financing regulations came into force. They updated the AML and the MLR regime, and it required that all UK crypto asset businesses must register with the FCA. Those existing businesses could carry on in compliance, provided they were registered by the then deadline of the 10th of January. It's now been extended to the 9th of July. New businesses had to register prior to commencing activities, but failure to register meant you had to stop. Everyone has to and will have to satisfy the fit and proper person test, which is familiar to many of you, I'm sure. And the FCA is particularly concerned with 6 core areas. They must take steps these businesses, these crypto asset businesses, to identify and assess the risk of money laundering and terrorist finance. They must have in place policies and systems to mitigate the risk of those issues. They must undertake customer due diligence, CDD, when entering into a business relationship. They must undertake enhanced due diligence, EDD, when dealing with customers who present a higher risk, and it particularly is appetite in respect to politically exposed persons or PEPs. There must be an undertaking of ongoing monitoring of customers to ensure that transactions are consistent with the business's knowledge of the customer and the customer risk, and it must keep a record of all risk assessments and customer DD measures. The FCA have powers to enforce disclosure. They also have powers to enforce reporting requirements. They can impose and cause a skilled person to be appointed to produce a skilled person report, and there's a power of direction which effectively allows them to seek to take over direction of the company and remedy any issues it says that it has problems with. So there are also just a few other areas as I come to the end of these points. Other things to be aware of, and these are significant when you are a practitioner. As of the 6th of January 2021, there's a complete and absolute ban on sale and distribution of crypto-related investment products, such as derivatives and exchange-traded notes. So absolute ban on that. And that's because the FCA have been concerned about the valuation of those particular assets. In January 2021, the UK Treasury announced the first stage of a consultation process with a view to a regulatory approach on crypto assets, and in particular, perhaps the most palatable of all of these, stablecoin. That consultation closed on the 21st of March. And that is something which I am absolutely sure will be something that develops and particularly in the UK develops as one of the very new markets, the stablecoin market. In April, 19th of April, so just last week, Bank of England and Treasury launched a central bank digital currency task force, and there is generally a recognition, and certainly I see it in the courts of England and Wales, a recognition that these aspects are the courts have actually bent over backwards to try and accommodate these new decisions in terms of tracing of Bitcoin. There's a big wave of theft of Bitcoin and cryptocurrency, given its huge value. And so what we are seeking to do, and what we hope to be able to do, and as well as in this seminar, as well as take some of your questions, but also in the next one, is to show you what the regulatory landscape is like, which way the wind is blowing, what's happening, and this is much more next time than this, what's happening in terms of how practical issues need to be dealt with and faced. All I can say before I hand over to Marc for a canter through, as it were, Switzerland, is that there's an awful lot of opportunity in this area, and provided, as I say, you get good advice, it's one that I think can be very profitable for people and for clients. So Marc, please take us through a look at Switzerland.
Thank you, Dean. So Switzerland is, of course, recognised as a long-standing global financial hub. It's a gold miner and a refiner, but today it really stands out as being a locus for digital gold, being home to more than 900 blockchain and cryptocurrency businesses, and being one of the leading jurisdictions for ICOs and STOs. Switzerland is also, of course, the seat of the Bank of International Settlements, the central bankers' bank based in Basel, as well as the so-called Crypto Valley near Zurich. In terms of some very quick facts, it's understood that 14% of asset holders in Switzerland also hold crypto, making it the joint highest country for crypto adaptation alongside Romania and Ireland. The country also reportedly has the 6th most Bitcoin ATMs in the world, total of just over 100, mostly based in Zurich and Geneva. And there are also Swiss-based exchanges, and perhaps you'll forgive the pronunciation, which I think is Danish. The exchanges such as Lika and the SIX Swiss exchange, which is often considered to be the country's principal stock exchange, which currently has, I understand, some 12 cryptocurrency ETPs listed. As Dean said, given time constraints, this is going to be a bit of a canter, and I don't propose to go into the minutiae of the regulatory position. But my opening and prevailing message is that Switzerland really does stand out in terms of its forward-thinking and embracing approach to cryptocurrencies and associated technologies. There is no separate legal framework for cryptocurrencies within the jurisdiction. What we have, however, seen recently is the grafting of specific features of DLT onto the existing legal framework, and I'll return to that point in a moment. In terms of the sufficiency of pre-2020, in terms of the regulatory regime that was in place then, that was explored by the Swiss Federal Council in a wide-ranging report in December 2018, which identified specific areas for legislative development. As another general point, it's important to note that Swiss law does not define the term cryptocurrency or indeed virtual currency. There's no statutory definition or case law on it. The best approach for the purposes of classification, which Dean obviously just dealt with in terms of the UK, is to rely on the token categories as defined by FINMA, the Swiss Financial Market Supervisory Authority, in its ICO guidelines report of February 2018. A second point to note is that cryptocurrencies do not qualify as legal tender in Switzerland, and there's currently no form of state-backed cryptocurrency. While the National Bank, the Swiss National Bank, has given no concrete indications about issuing a cryptocurrency, this, I would suggest, is something nevertheless to keep an eye on, particularly as there is an operational agreement in place between the bank and also the Bank for International Settlements regarding the BIS Innovation Hub Centre, the aim and purpose of which is to develop associated technologies, including the integration of digital central bank money into DLT infrastructure. So I've just referred to the February 18 ICO guidelines, which for those interested and practitioners who may be looking at this market, I would invite you to look at in your own time. However, in those guidelines, FINMA sets out how to classify cryptocurrencies and other coins or tokens registered on distributed ledgers under Swiss law. Dean provided a walkthrough of the UK provisions. In Switzerland, it's not dissimilar. According to the guidelines, FINMA distinguishes tokens into 3 categories, the first being payment tokens or cryptocurrencies, and these are naturally only intended to be a means of payment. They do not give rise to any claims against the issuer. Secondly, utility tokens, which provide rights to access or use a digital service or application, provided that the same already exists, i.e. that it's already operational at the time of the sale. And thirdly, asset tokens, which clearly represent an asset, for example, a debt or an equity claim against the issuer or third party, or a right in an underlying asset. FINMA also acknowledges that these tokens can be hybrid, in which circumstances the token must comply with the requirements of each category that it happens to engage. Unsurprisingly, for the purposes of assessment, the moment of the token issuance is relevant. However, that initial classification may also change post-ICO. Likewise, in the event of a secondary market trading, the moment of the relevant trading activity is also taken into account for classification purposes. Now, in terms of recent developments, obviously today we are providing a current update. One particularly noteworthy update, which I wanted to mention, is the so-called DLT or Blockchain Act, which you may have seen referred to in the news either last summer or possibly again in February of this year. This was a suite of legislation coming, as I say, in August 2020 that amended several civil and financial market laws in Switzerland. In a nutshell, the legislation was designed to pave the way for DLT uptake into the broader economy generally, and it will facilitate, it's expected, the creation of tokenized versions of, for example, company shares, real estate holdings, art, etc., that can be listed and traded on blockchains in Switzerland. So in terms of the key points to note in terms of that particular new legislation, which, as I say, has been making waves, firstly, the legislation provides for the trading of DLT rights as an alternative to, say, certificated securities through electronic registers, i.e., the rights are transferable exclusively through the blockchain. So, by way of background in terms of what I mean by this, tokens in the form of cryptocurrencies are classified as intangible assets under Swiss civil law, which doesn't provide any specific requirements for or obstacles to the transfer of tokens that represent a value, such as cryptocurrencies. However, to improve legal certainty, the Blockchain Act, as it's known, regulates the transfer of rights on the blockchain by means of digital registers. It does this by introducing a new category of ledger-based securities into the Code of Obligations and uses wording that is technology neutral. The effect of this, well, the bottom line for this is that a bona fide purchaser that's relying on the content of the register and the transfer is able to, in any event, be subject to the terms of the registry agreement, thus providing legal certainty that was hitherto unavailable. The second key aspect of this act is that it provides for segregation of crypto-based assets in the event of bankruptcy. This does what it says on the tin. In effect, it means that crypto assets will be segregated when the custodian has exclusive actual power of disposal over the relevant crypto assets. Thirdly, and perhaps most importantly, there is a new license category for DLT trading systems, and this potentially increases the scope for more trading venues where DLT rights can be traded. So taken together and put more generally, as of the 1st of February 2021, when the first raft of legislation came into effect, Switzerland permitted tokenized security trades on the blockchain to have the same legal standing as traditional assets. And commentators have said that this law change further cements Switzerland as being one of the most advanced jurisdictions in the world for crypto, along with Singapore, which we're going to come to in a moment, and arguably, increasingly, I would suggest, the United Kingdom. And perhaps that's a good moment for me to hand over to Ceri, who's going to discuss the Singapore position.
Thanks, Mark. I'm conscious of time, so this is really going to be a whistle-stop tour of the regulatory regime in Singapore. But I'd also just like to remind everyone that at the end of this section, we'll be doing a question and answer session. So if you have any questions, just pop them in the Q&A box and we will have a look at them. So I guess the first preliminary thing to say about Singapore is that cryptocurrency is considered to be property in Singapore, one of the first jurisdictions to come to that conclusion, including the UK. In the B2C2 case, the Singapore International Commercial Court, the judge observed that cryptocurrencies have the fundamental characteristic of intangible property as being an identifiable thing of value and that they meet all of the requirements in National Provincial Bank. Bearing that in mind, and then moving on to the actual regulation of cryptocurrency in Singapore, the regulator is the Monetary Authority of Singapore. Unlike the FCA, the MAS has issued warnings to investors and the public of the risk of investing in cryptocurrency products. Singapore's crypto asset regulations cover the licensing of crypto asset businesses, AML and CFT compliance, ICOs, and platform activities. But very broadly speaking, the regulatory regime that applies depends on whether the crypto asset is considered a capital market product, such as a security or a unit in a collective investment scheme or a cryptocurrency. If it's a cryptocurrency, it falls under the Payment Services Act, whilst capital market products fall under the Securities and Future Act. Turning then to the licensing of cryptocurrency businesses. In 2019, the Payment Services Act was passed. That came into effect in January 2020, and that provides that a person must not carry on a business of providing any type of payment service in Singapore unless they have a license or are exempt. A payment service includes a digital payment token service, which is defined as any service dealing in digital payment tokens or any service of facilitating the exchange of digital payment tokens. The definition of a digital payment token is defined in the Payment Services Act 2019, and the full list of provisions, regulations and definitions are provided in the digest that you will receive tomorrow after the webinar. But just sort of as a summary, the MAS has recognised Bitcoin and Ether as digital payment tokens. So cryptocurrency businesses fall under these licensing provisions. The application for a license must be made to the MAS, and there are different types of licenses, and the type of license that needs to be applied for depends on the average monthly total value of all payment transactions that are accepted, processed or executed, and failure to obtain a license is an offence punishable by a fine. In December 2019, the MAS released a notice on the AML and CFT requirements that digital payment token service providers were expected or are indeed required to comply with. This was supplemented with guidelines in March 2020, and an overview of the supervisory expectations was issued in March 2021. The AML and CFT requirements are very similar to those in the UK, so they will be familiar to many. So it's things like take appropriate steps to identify and assess and understand the risks, develop and implement policies, customer due diligence, record keeping, reporting suspicious transactions, etc. Singapore also has other legislation for combating money laundering and terrorist financing, which all persons have to abide by. And these are also reporting suspicious transactions, prohibitions on dealing with or providing financial services to designated individuals and entities. Again, things that many practitioners will be familiar with. In January of this year, the Payment Services Amendment Bill was passed, and this amended the Payment Services Act 2019. The amendments are not yet in force, but what they do is they broaden the definition of digital payment token service, and therefore the entities that will need to be licensed and comply with the AML and CFT requirements. These amendments were brought in to align with the enhanced regulation standards adopted by the Financial Action Task Force in regulating VASPs. And in summary, the digital payment token services that will require a license and need to comply with the AML requirements will now include those that transfer digital payment tokens, provide custodian wallet services for digital payment tokens, and those that facilitate the exchange of digital payment tokens, even where the service provider does not come into possession of any monies for the digital payment tokens. The amendments also expand the powers of the MAS to impose additional measures and regulatory requirements on service providers. That's because the current primary regulation for these service providers is AML and terrorist financing risks. But these new provisions allow the MAS to implement new measures, such as consumer or user protection measures to ensure the safekeeping of customer assets held by the service provider, and importantly, other measures where the MAS considers it necessary or expedient in the public interest or in the interests of the stability of the financial system in Singapore or the monetary policy of MAS. That gives them quite a large remit to introduce any regulations that they see necessary. So that deals with effectively cryptocurrencies, but moving then to the capital market products. For an initial coin offering from a capital market product, I'm going to start again with this. ICOs that are for capital market products fall under the Securities and Futures Act, and they must comply with those requirements unless they exempt. These requirements include things like they need to have a prospectus that is prepared in accordance with the Securities and Futures Act and is registered with the MAS. Exemptions, however, include things like it's a private placement or offer that is made to 50 persons within a 12-month period or made to institutional investors. One of the other requirements is that anyone who is operating a platform on which one or more offerers of digital tokens may make primary offers or issues of digital tokens. If those tokens are capital market products, they may be carrying out a regulated activity. In Singapore, carrying on business in any regulated activity or holding oneself out as carrying on such business, you must hold a capital market service license under the Securities and Futures Act. In looking at exchanges, what is listed on an exchange determines the licensing requirements and the regulatory regime. If an exchange lists any tokens that are capital market products, its activities are regulated by the Securities and Futures Act, and it must be approved by the MAS as an approved exchange or recognised by the MAS as a recognised market operator under the Securities and Futures Act. As I've already indicated, where it's cryptocurrencies, not subject to the Securities and Futures Act, but the Payment Services Act. In terms of holders of capital market services, the MAS issues notices as to the AML and CFT requirements. These are very similar to those imposed on digital payment token service providers that I've already outlined and will be outlined in the digest. And again, it's also the additional legislation that is to combat money laundering and terrorist financing that all persons in Singapore have to abide by. And with that, I am very conscious of time. That was an incredibly quick whistle-stop tour. As I say, everything will be in the digest so for you to read at your leisure. But with that, I will hand back to Dean and we can see what questions we have.
Thank you very much, Ceri. Can I commend the digest to you? You will be getting it tomorrow. It genuinely is a fabulous way of having a lot of the hard work done for you, as we have been delighted to do. It gives, as I say, it strips down a lot of the things and gives you a lot of the references that we've been talking about today. So that it's a very, very good whistle-stop look, but it also can push you, if you'd like, into directions so that you can look further into the concepts we've been talking about today. Yes, I am going to act as MC for some questions. At the moment, there are 3 questions or two parts to a question, both from Neil. So I'm going to have a go at answering those. And then I've just seen there's another one, so we'll look at that hopefully in a moment. But let me just introduce the questions, at least the subject matter that Neil has asked us. The first is, he talks about effectively sanctions, and his ultimate question is whether you have any news that the list of sanctions activities are likely to become more structured or separated specifically for crypto sanctions checks. The answer, Neil, is that I am pretty confident that that will happen. And the reason I think it will happen is because, as we've outlined today, and as I'm sure you'll be aware, crypto assets became subject to AML and sanctions regimes in recent times, beginning of last year. And because there appears to be, and if you didn't attend number 1 in this series, which is a webinar on ransomware, it is, I think we are the stars of Spotify, certainly on that one. It is on some of the social media and some of the platforms. So you can listen to that where we talk about ransomware and settlement of ransomware demands. But in short, because there is a prevalence of settlement in Bitcoin and the like, I think, and particularly since, as we've sought to explain, there is definitely a sensitivity amongst governments and vested interest, is my expression. It's pretty likely that we're going to be moving towards crypto sanctions checks, not least because most ransomware settlements are in Bitcoin. I don't think that should mean that anyone should be scared of that, because, as I am on record as saying, the one thing you have about cryptocurrency, you have an immutable evidential trail because of its blockchain activity. So that's the first part of your question. The second part of your question is, do you expect crypto cold storage providers to be regulated? let me just explain in 2 lines what a crypto cold storage is and what a provider is. Cold storage, otherwise known as cold wallets, means generating and storing a crypto coin's private keys offline, so away from the internet. My answer to that is Neil, that I think it is likely that will form part of the regulatory landscape. The internet, candidly, is not the determining feature in this. What is the determining feature for me is the nature of the asset, the crypto asset that we're talking about. So I don't think that cold storage providers will be exempt simply because they don't use the internet. I think it will be something which ultimately there will be regulation over. What we've got to be very careful here is that we don't over-regulate this market. Sadly, there are many markets in the UK that are already over-regulated, and it's one of those things that we just got to make sure we don't strangle this new technology too early, but have it properly evaluated so it can gain confidence in the system. There are some other questions. There are 2 from Professor Lisa Short. I'm going to sound them out and say them out loud and ask one of my co-panelists to pick them up. First one, what do you think is the real driver for these new regulations? What impact will this have to the everyday person? Second, crypto by nature are ubiquitously decentralized. These regulations are jurisdictional. Are these dramatically opposed? So can I ask whoever would like to pick that up? So effectively, it's the driver for the new regulations and the issue of jurisdiction.
I will start with the driver one, Dean.
Yes.
I think it's partly, well, it sort of goes to all the things that are coming to force this year, the realization that crypto is here to stay. It's not going away. It hasn't just been a fad. It's here to stay. It's going to form part of people's lives. It's going to form part of the financial ecosystem. And the realization that people want to regulate it as a result. So I think that's it on one hand. The other hand is potentially some of the headlines that have happened because of the frauds, the ransomware attacks that have happened. And partly the realization that it is here to stay. If these areas are regulated, effectively ensuring consumer confidence that these are safe, and that will then provide further growth. And I think that's probably one of the real drivers, unless anyone else has any views or wants to disagree.
Yeah, Marc and Celso, would you like to comment on that?
Yeah, I would. I mean, I think in addition to consumer protection, which is of course central to the regulatory attitude of any government, I mean, this is more of a political observation, but I wholly agree with what Ceri has said, that cryptocurrency and associated assets are here to stay, and they are not just assuming a role on the financial landscape, they're assuming a central role. And when you have that, and when we have, as Professor Short says, crypto is by nature decentralized, that gives rise to an urgency, I believe, in governments to reassert control over something where fundamentally it doesn't have control, and the law has previously been slow to react. I think that's partly, there are political drivers that are pushing through regulations. I don't know, Celso, do you have any thoughts on that?
And also, Celso, could you deal with the jurisdiction point? I'd be very grateful. Thank you, Marc.
I agree with what everyone has said. I'll just add 2 comments. I think that the tension here is how regulation can be very good for business of the regulated entities if it gives protection to the users of that industry as against those that don't have protection, and therefore they're not going to use the exchanges in those areas, in those jurisdictions that don't have protection. So the regulation itself can be a competitive advantage. The problem is that you can overegg the pudding, and you can end up having too much regulation that basically stifles development and then move new entrants to the market to another jurisdiction because there is a cost attached to it. And I think that for a while we are going to end up in a dual world. Some countries are going to have more regulation, and therefore they're going to attract bigger and more institutional investment. And other countries are not going to have so much regulation. The risk is going to be higher, and it will take a while for them to catch up to have the same regulatory equivalence. So it is all about international regulatory equivalence. And I hope that's to some extent, this deals with the jurisdictional issue. But the decentralization point, I have my own views about this. I don't think that the claim of decentralization, it may be technically arguable from an IT perspective, but it hasn't been legally tested. And one of the things that you see with the US proposals and the international proposals, the FATF's proposals, that they will try to regulate decentralized exchanges. And you see, the horror of trade organizations saying, but these are decentralized exchanges. They have no control, no custodial control. Therefore, you cannot regulate them, and it will not work. The regulation will not work. I am not sure that the regulation will not work. I think if it is a truly, absolutely decentralized sale of a software for a license with no monitoring, for instance, that is easier to show that there has been there hasn't been any retention of control of the platform or the software. But if there is any custodial repair type of control, and the information, the KYC information, is obtainable, it is easier for the regulatory authorities to impose the duty. So the decentralization point is going to be, in my view, the big argument that is going to be litigated and argued over in 2022, 23, 24, I think.
Thanks very much, Celso. Probably one last question, unless anyone wants to rapidly send us one, but it's from Shyam Thakrar. To what extent do exchange platforms in the UK owe a duty of care to users? Many advertise themselves as being safe and secure, but users are very often defrauded with a limited ability to trace their assets. Is there presently any recourse against the exchange in the absence of regulation? Thank you, Shyam. Two things that I'm going to say in dealing with this. The first is, this is a brilliant appetizer for those that would wish to come and listen to our next part 2 of this, because it's absolutely on point of what we're going to be talking about. We're going to be talking about practical considerations as to how one recovers Bitcoin, crypto assets, cryptocurrency from exchanges and beyond. In short, the answer is that the exchange platforms do. They depend. There are some extremely good exchange platforms which have very, very watertight and credible conditions. There is one that I'm currently dealing with, which, despite the fact that everything happens in the UK, has an exclusive jurisdiction clause in Bulgaria. That's always a bit of a worry, because it rather looks as if there may not be perhaps as a stand-up as they might. But the answer to your question, Shyam, is yes. In terms of the court's proactive stance on this, in terms of different orders, Norwich Pharmaceutical Bankers Trust and the like, yes, there is a duty of care, and there is often a very, very good chance of recovery. Can I just add a little tip, a useful piece of legislation, which those of you engaged in this field, and particularly in relation to that last question that Shyam has just asked, what is very interesting, and what is something that certainly happens in my area of practice, often these matters are international, and it's back to Lisa Short's jurisdictional issue. Often these issues are international, and you've got international exchanges with UK transactions. A very good, and this is on the digest, a very useful piece of legislation is Section 25 of the Civil Jurisdiction and Judgments Act of 1982. That permits interim relief, so interim relief to be sought in England and Wales in respect of proceedings that will ultimately be governed by a foreign jurisdiction. So the way you do that is you start your your case and you get interim or seek interim relief in the UK on the proviso that you will start final determination, as it were, of the matter in a foreign jurisdiction. But it's a very useful piece of legislation, I'm sure not enacted for cyber in 1982, but of huge value to those of us who practice in this area. So the answer to your question, Sham, is yes, there is recourse. Yes, there is a duty of care. And yes, it will be worth waiting, if you don't mind, to part 2 of this to have a completely full discussion. With that, I notice it's 8 minutes past 5. I think probably we are at an end. Can I thank everyone for their attention? Can I thank everyone for the questions they've sent in? Can I just give a few closing notices before I, as I say, we all wish you a very good afternoon. The first is that part 2 of this is on the 24th of May. It's entitled Cryptocurrency Tracing and Remedies, Practical Considerations. And but it's also right to say that 36 Commercial is not idle. There are 2 other webinars in the offing. The first is Commercial Crime, Interim Account Freezing Orders under POCA, latest developments. That's going to be conducted by Philip Hackett QC and Rachel Muldoon. And on the 11th of May, one of the other hot topics at the moment in this crypto world, as it were, is cyber private wealth, NFTs, blockchain and cryptocurrency, translating new technology into profit. And I'll give you fair warning that I'm on that panel. So that may either attract you to it or it may not. But can I say thank you very much and much appreciated for your time. We look forward, we hope, to seeing you again at our next one. Please look out for the digest that will be coming your way tomorrow. And please look us up on YouTube and also on the podcast 36 Commercial View from the Bar. Very good afternoon to you all.